Hello, Andrew Reed here with my NCA exam study guide for constitutional law, and we're going to be looking at Part 9, Aboriginal Rights. So what I'm doing here is I'm just going through the syllabus and case briefing and writing notes on their hyperlinks. And so let's go ahead and get started. Part 9, Aboriginal Rights. So right off the bat, the syllabus refers to Sections 25 and Section 35 of the Constitution. So Section 25 says, "The guarantee in this charter of certain rights and freedoms shall not be construed as to abrogate or derogate from any Aboriginal treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including rights or freedoms recognized by the Royal Proclamation of October 7th in 1763, or any rights or freedoms that now exist by way of land claims agreements or may be so acquired in the future." And Section 35 is the recognition of existing Aboriginal treaty rights. So it just says the existing Aboriginal treaty rights of the Aboriginal people of Canada are hereby recognized and affirmed. Goes on to define Aboriginal peoples in Canada by saying it includes the Indian, Inuit, and Métis people of Canada. Then land claim agreements for greater certainty. In subsection 1, treaty rights includes rights that now exist by way of land claims agreements or may so be acquired. Aboriginal treaty rights are guaranteed equally to both sexes, and there's a commitment to participation in constitutional conference. So any amendment, the principle before any amendment is made to Class 24 of Section 91 to Section 25 of the Act, or to this part, that a constitutional conference includes in its agenda an item relating to the proposed amendment composed of the Prime Minister of Canada and the First Ministers of the provinces, and will be convened by the Prime Minister of Canada, and that the Prime Minister of Canada will invite representatives of the Aboriginal peoples of Canada to participate in the discussions on that item. Okay, that's Section 35. There's three cases that I'm going to cover here, Sparrow, Vander P, and Pali. Let's get started with Sparrow in 1990. The issue here was whether or not a net length restriction was inconsistent with Section 35(1) of the Constitution Act. So the background here, the appellant was charged in 1984 under the Fisheries Act with fishing with a net longer than that permitted by terms of his fishing license. He admitted that the facts alleged constitute the offense, but defended the charge on the basis that he was exercising an existing Aboriginal right to fish, and that the net length restriction contained in the license was invalid, and that it was inconsistent with Section 35 of the Act. He was convicted. The trial judge found that a right cannot be claimed unless it was supported by a special treaty, and therefore the Section 35 had no application. They attempted to appeal, and that was dismissed as well. However, they felt that the Court of Appeal then found that the trial judge's finding of facts were insufficient to lead to an acquittal. The second appeal after the fact. Their decision was appealed and cross-appealed to the Supreme Court. And so the question now before the Supreme Court is just asking whether the net length restriction contained in the license is inconsistent with Section 35. So some notes, I suppose you can call it a rule here. Section 35 is to be construed in a purposive way. A generous liberal interpretation is demanded, given that the provision is to affirm Aboriginal rights. The provision is not subject to Section 1 of the Canadian Charter of Rights and Freedoms. Any law or regulation affecting Aboriginal rights, however, will not automatically be of no force or effect by the operation of Section 52 of the Constitutional Act. Legislation that affects the exercise of Aboriginal rights will be valid if it meets the test for justifying an interference with the right recognized and affirmed under Section 35(1). And this court goes out to lay out the very famous Sparrow Test. So in conclusion, they dismissed the appeal and cross-appeal and wanted this question sent back to trial to be answered according to the Sparrow Test. So analysis from the Sparrow Test. The first question to be asked is whether the legislation in question has the effect of interfering with an existing Aboriginal right. So that inquiry will begin with a reference to the characteristics or incidents of the right at stake. Courts must be careful to avoid the application of traditional common law concepts of property as they develop their understanding of the sui generis nature of Aboriginal rights. To determine whether the fishing rights have been interfered with such as to constitute a prima facie infringement of Section 35, certain questions must be asked. Is the limitation unreasonable? Does the regulation impose undue hardship? Does the regulation deny to the holders of the right their preferred means of exercising the right? So the onus of proving that prima facie infringement lies on the individual or group challenging the legislation. The regulation would be found to be a prima facie interference if it were found to be an adverse restriction on the exercise of the native's right to fish for food. In this case, fish for food. The test involves asking whether either the purpose or the effect of the restriction unnecessarily infringes the interest protected by the right. If a prima facie interference is found, then the analysis moves to the issue of justification. First, is there a valid legislative objective? Here, the court's going to inquire into the objective of Parliament in authorizing the Department to enact regulations regarding the issue, the interest. The objective of the Department in setting out the particular regulations would also be scrutinized. So the public interest justification, way too vague. However, conservation and resource management, that would be quite reasonable, according to this court. If a valid legislative objective is found, the analysis proceeds to the second part of the justification issue, which is honoring the crown, the honor of the crown in dealing with Aboriginal peoples. There must be a link between the question of justification and the allocation of priorities. The constitutional recognition and affirmation of Aboriginal rights may give rise to conflict with the interest of others given the limited nature of a resource. So the justificatory standard to be met might place a heavy burden on the Crown, and the court's okay with that. Section 35 requires the Crown to ensure that its regulations are in keeping with that allocation of priority and guarantees that those plans treat Aboriginal peoples in a way ensuring that their rights are taken seriously. Within the analysis of justification, a few further questions to be addressed, depending on the circumstances of the inquiry. So those include whether there has been as little infringement as possible in order to affect the desired result, whether in a situation of expropriation fair compensation is available, and finally whether the Aboriginal group in question has been consulted with respect to the conservation measures being implemented. This is not an exhaustive list. So Sparrow leads to Vander P in 1996. Background in this case, appellant, a native, was charged with selling 10 salmon caught under the authority of a fish license. And so that was against the British Columbia fishery regulation, which said you can't sell or barter fish caught under such a license. So these restrictions imposed were alleged, in this case, to infringe the appellant's Aboriginal right to sell fish, and they said they were invalid because they violated Section 35 of the Constitutional Act. So the trial judge held that the Aboriginal right to fish for food and ceremonial purposes did not include the right to sell such fish and found the appellant guilty. The summary appeal judge found an Aboriginal right to sell fish and remanded for a new trial. The Court of Appeal allowed the Crown's appeal and restored the guilty verdict. And so this was appealed again to the Supreme Court by the appellant, the native, and the court said in this case the appeal should be dismissed. Still guilty, no protected right here. So the issue in this case, whether Section 27.5 of the British Columbia regulations was of no force or effect in the circumstances by reason of the Aboriginal rights within the meaning of Section 35. The rule here, in ambiguity as to the scope and definition of Section 35, must be resolved in favor of Aboriginal people. Aboriginal rights existed and were recognized under the common law. They were not created by Section 35, but subsequent to Section 35, they cannot be extinguished. They can, however, be regulated or infringed upon consistent with the justificatory test laid out in R.B. Sparrow. Section 35 should be viewed as protecting, not a catalog of individualized practices, customs, or traditions, but the distinctive culture of which Aboriginal activities are manifestations. So not a list, but the culture itself. The emphasis is on the significance of these activities to natives rather than on the activities themselves. They should be distinguished from the practices or habits which were merely incidental to their lives, and those would not warrant protection. A generous, large, and liberal construction should be given to these activities in order to give full effect to the constitutional recognition of the distinctiveness of Aboriginal culture. What constitutes a practice, custom, or tradition distinctive to Native culture and society must be examined through the eyes of Aboriginal people. And this is all text coming from the Vander P case, and these new rules take effect here. So the Vander P test, the Aboriginal activity must have formed an integral part of a distinctive Aboriginal culture for a substantial and continuous period of time. This period should be assessed based on 1. The type of Aboriginal practices, customs, and traditions. 2. The particular Aboriginal culture and society. And 3. A reference period of 20 to 50 years. This approach gives proper consideration to the perspective of Aboriginal people on the meaning of their existing rights. So this test is broken down further in the analysis as it's applied. This court consolidates and clarifies the Sparrow Test into a nice little package that's included here. So the Sparrow Test being first, a court must determine whether an applicant has demonstrated that he or she was acting pursuant to an Aboriginal right. Second, a court must determine whether that right has been extinguished. Third, a court must determine whether that right has been infringed. Finally, a court must determine whether the infringement is justified. Some additional notes. The time period that a court should consider in identifying whether the right claimed meets the standard of being integral to the Aboriginal community claiming the right is the period prior to contact between Aboriginal and European societies. Okay, so the analysis here in the Vander P case, and this breakdown contains a lot of detail because this is similar to what I assume that they're looking for on the NCA exam. So the first step in the application of the distinctive culture test requires the court to identify the precise nature of the appellant's claim to have been exercising an Aboriginal right. So in this case, she's claiming an Aboriginal right to exchange fish for money or for other goods. She's claiming that the practices of the Stolo people include as an integral part the exchange of fish or money or other goods. So in this case, she sold 10 salmon for $50. Such a sale, especially given the absence of evidence that the appellant has sold salmon on other occasions on a regular basis, cannot be said to constitute a sale on a commercial or market basis. These actions are instead best characterized in the simple terms, an exchange of fish for money. It follows from this that the Aboriginal right pursuant to the appellant is arguing that her actions were taken is, like the actions themselves, best characterized as an Aboriginal right to exchange fish for money or other goods. She does not need to demonstrate a right to sell fish commercially. The evidence linking the exchange of salmon to the maintenance of kinship and family relationships does not support the appellant's claim to the existence of an Aboriginal right. Exchange of salmon as part of the interaction of kin and family is not of independent significance sufficient to ground a claim for an Aboriginal right to the exchange of fish for money or other goods. Given the exchange of salmon was not widespread, it can't be said that prior to contact, the Stolo culture was defined by trade in salmon. Trade or exchange of salmon may have took place, but the absence of a market demonstrates that this exchange did not take place on a basis widespread enough to suggest that the exchange was a defining feature of Stolo society. Third, the trade engaged in between the Stolo and the Hudson's Bay Company, which certainly of significance to the Stolo society at the time, was found by the trial judge to be qualitatively different from that which was typical of the Stolo culture prior to contact. As such, it does not provide evidence for holding that the exchange of salmon was an integral part of Stolo culture. The absence of specialization in the exploitation of the fishery is suggestive that the exchange of fish was not a central part of Stolo culture. So this judge is not finding that and agreeing with the trial judge that the Stolo did not have means for preserving fish for extended periods of time, something which is again suggestive that the exchange or trade of fish was not central to the Stolo way of life. So for these reasons, this judge concludes the appellant has failed to demonstrate that the exchange of fish for money or other goods was an integral part of the distinctive Stolo society which existed prior to contact. Since the appellant has failed to demonstrate this, it's unnecessary to consider the test for extinguishment, infringement, and justification laid out by this court in Sparrow. So couldn't pass the threshold test, and case lost there. Okay, which brings us to the third case here, Pali Pali case, which comes with a test of its own. So the issue, whether members of this Metis community have constitutional Aboriginal right to hunt for food in Sault Ste. Marie, and if so, whether that infringement was justifiable. And the court rephrases this issue as to whether subsections 46 and 47 of the Game and Fish Act, Provincial Act, which prohibit hunting moose without a license, unconstitutionally infringe the Aboriginal right to hunt for food, as recognized in Section 35. Background. The respondents, who are members of a Metis community, were acquitted of unlawfully hunting a moose without a hunting license in contravention of the Ontario Game and Fish Act. Trial judge found that members of the Metis community around the area have an Aboriginal right to hunt for food that is infringed without justification by the Ontario legislation. And the Superior Court of Justice and the Court of Appeal upheld the acquittals, but that didn't stop Ontario. They appealed to the Supreme Court. And the Supreme Court upheld the rights and dismissed the appeal. And main rule being here, aside from the Vander P test, which is modified, just Section 35 of the Constitution Act. So the analysis is that the overarching interpretive principle for the legal analysis here is the purpose of reading of Section 35. The inclusion of the Metis in Section 35 is based on a commitment to recognizing the Metis and enhancing their survival as distinctive communities. And the purpose and the promise of Section 35 is to protect practices that were historically important to that culture. So the inclusion represents Canada's commitment to recognize and value the cultures. And this can only be done if the Metis are protected alongside other Aboriginal communities. So with that in mind, they modify the Vander P test to determine the entitlements of the Metis people under Section 35 of the Constitution Act. So the appropriate test must then be applied to the findings of fact of the trial judge, and they're using Vander P as a template. But they modify the pre-contact focus of the Vander P test when the claimants are Metis to account for the important difference between those people. Section 35 requires that we recognize and protect the customs and traditions. So first step in this modified test, which what we call the Pali Test, is to characterize the right being claimed. This is from the Vander P test, really. Aboriginal hunting rights, including Metis rights, are contextual and site-specific. The respondent shot a bull moose. Within the hunting grounds, they said the moose is intended to provide meat for winter. Trial judge determined they're hunting for food. No reason to overturn that. The right being claimed can therefore be characterized as the right to hunt for food in the environs of Sault Ste. Marie. So you can see here they have analyzed the right by using this test. We agree with the trial judge that the periodic scarcity of the moose does not in itself undermine the claim. It's not the right to hunt moose, but the right to hunt for food in the territory. The trial judge also found that there was a distinctive Metis community in that area. In addition to demographic evidence, proof of shared customers, traditions, and a collective identity is required just to demonstrate that existence. And so different groups of Metis have often lacked political structures, have experienced shifts in their self-identification, but the existence of an identifiable Metis community must be demonstrated with some continuity and stability. But the trial judge found that there was a historic Metis community there. The Supreme Court didn't want to overturn that. Aboriginal rights are communal rights. They must be grounded in the existence of history and the present community. They must be grounded in the existence of a historic and present community. And they may only be exercised by virtue of an individual's ancestry, ancestrally based membership in the present community. So the trial judge found that the community was there. Even though it was a little bit hidden, diminished, they may have gone underground, but either way, there was a community, and there was the continuity requirement was then in that case. So then here's the actual Pali test that comes out to. They want to look to three broad factors as indicia of Metis identity for the purpose of claiming Metis rights under Section 35. Self-identification, ancestral connection, and community acceptance. So first, self-identification. The claimant must self-identify as a member of the Metis community, should not be of recent vintage. It doesn't have to be static or monolithic, but just claims made just to benefit from the right will not satisfy it. Okay, self-identification. Ancestral connection, the second one. The claimant must present evidence of an ancestral connection to a historic Metis community. So there has to be a real link to the historic community, not necessarily blood quantum, tracked DNA or anything like that, but some proof that the claimant's ancestors belong to the historic Metis community by birth, adoption, or other means. And then third, finally, community acceptance. So the claimant must demonstrate that he or she is accepted by the modern community, whose continuity with the historic community provides the actual legal foundation for the right being claimed. So membership in a Metis political organization might be relevant, but not sufficient. The core of community acceptance is past and ongoing participation in the shared culture, in the customs and traditions that constitute a Metis community's identity and distinguish it from other groups. Okay, so that is Sparrow, Vander P, and Pali. So concludes Part 9 of the NCA Exam Study Guide. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.